Okay, the issue of peer review is of critical importance to the medical profession and even more importantly for our patients. And for that reason, we're very grateful for the opportunity to be here today. The first set of questions that you did present to us is how the peer review system is affecting our members and what problems they currently face. As you may be aware, CMA represents a number of physicians in all specialties and in different practice forms, and they do at times have different opinions. But with respect to this issue, they are uniform on the fact that the peer review must be conducted for quality reasons only and that the process needs to be fair. Before we get into the specifics, I want to talk very briefly about what is and what is not peer review. The goal of peer review is not to file an 805 report, and it's not to get the bad guy, and it's certainly not to get the guy that you don't like. Rather, peer review involves a continuous assessment of a physician's practice, given the resources and capabilities of a facility, the provision of recommendations for improvement and education, and where necessary, and only when necessary, the initiation of disciplinary action against a physician where there's a threat to patient care. As we heard from Dr. Lowe, many medical staffs, in fact, do have robust peer review that is working as the law intended, and for that reason, the number of 805 reports that are filed with the medical board should not be construed as a marker of quality of care, because these medical staffs take educational and corrective action early on, before an 805 report is needed and before patients are injured. As with any system that's been around, and this system's been around, the 805 reporting has been around since the 70s, and the last time the legislature took a big look and a big chunk at the fair hearing rights was in 1989. Issues have surfaced that have hindered the proper functioning of peer review. On the one hand, we hear from our medical staffs that they have difficulty in conducting timely and effective investigations and disciplinary actions. And on the other hand, we have heard from physicians that peer review may have been motivated for reasons other than quality of care. The latter issue does undermine the entire peer review system for a number of reasons, largely due to the fact that this action ruins a physician's lives as it becomes a matter of public record. And it does more than ruin a physician's livelihood. If it's an unfair 805 report, it destroys continuity of care, something that both the medical literature and the courts have recognized is so important to quality. There's the reputational damage with an unfair 805 report, because again, it's not just taking away money, it's saying that you're incompetent. And finally, there's an impact on peer review system as a whole. Physicians understand and value their obligation as a peer review and to perform peer review. But for a peer review to work, what the physicians have reported in the medical literature and to the California Medical Association, that the system needs to encourage frank and open discussion, needs to be for the purpose of quality improvement and be non-punitive. Physicians who believe that this system is unfair will be less likely to participate. To be sure, given the passions and the interests involved, there are disagreements in terms of how those elements of a functioning peer review system should be achieved. The Lumetra study is an example of the disagreement. We have prepared an analysis of why we disagree with the Lumetra's ultimate recommendation, that is taking a wrecking ball to the entire peer review system, by the way, without a single example of an 805 report that should have been filed but wasn't. But in addition to our concerns that the methodology used was flawed, many of the issues that the Lumetra report was concerned about have in fact been addressed, but not mentioned in the Lumetra report by recent Joint Commission standards. And we do thank you and your staff for inviting the Joint Commission to speak to you about those new standards in terms of how they do resolve some of those critical issues that were raised. And I'm going to just briefly talk about it, since make it my 7 minutes, in terms of the ongoing professional practice evaluation. This standard became effective in 2007 and is now being measured. And under this standard, every practitioner on the medical staff, every single one, gets evaluated and gets evaluated continuously, meaning more than just at reappointment. And under the Joint Commission's, the FAQs, it's got to be even more than once a year. It's pursuant to a data-driven process. No one escapes this process, and there needs to be tracking of what happens with the peer review recommendations and analysis of the physician's practice. Having said that, like any other system, there could be some improvements, and we urge for you to work with us to see that they happen, but it's more of a tune-up and not a demolition or a wrecking ball. Areas that we would like to see that go a long way to improving peer review include a three-part strategy that we would like to see happening, and one is providing better tools to see that it happens. One of the issues that came up in a case currently pending before the Supreme Court is the requirement that peer review bodies be required to share peer review information with each other. Currently, some peer review bodies don't share information in terms of their peer review findings and their records because they're concerned about the disclosure of that and the impact that that could have in terms of liability. We believe that there should be a legislative direction requiring the sharing of information along with appropriate immunities so that the sharing of peer review information can be done in a pro-competitive, pro-quality mechanism. Finally, we believe that there should be provisions in place to ensure that peer review happen and not be circumvented by contractual provisions. We need to ensure fairness and make some modifications to the peer review law. Fairness, again, not only to protect the physicians that are under review, but to promote physicians' willingness and ability to participate in that program. Third-party review, where necessary. There are medical staffs where it is worthy of having external review, such as where impartiality cannot be guaranteed, where there's not expertise on the medical staff, or, quite honestly, where you need to get another opinion. Right to an outside hearing panel where necessary to ensure confidentiality should be required where the licentiate under review believes that it's necessary. Third, a right to an attorney. Physicians that are being charged and subject to an 805 report have no right to an attorney under California law. And that is a necessary predicate, by the way, of the immunities under the federal system, the Federal Healthcare Quality Improvement Act. And that right also does the third thing that we're looking to do in our legislation, which is speed up the process. Make sure that it happens efficiently and effectively, and we think that an attorney present with the physician will also achieve that goal. As do we with empowering hearing officers to take actions to help speed up and control the hearing panel so that it moves quickly at the outset. In sum, we thank you for this very important opportunity to address you and look forward to working with you on making improvements that promote quality care and not defeat it. Thank you.
Thank you very much.